Hello, my name is Lisa Collins. I am a solicitor advocate, and this webinar will be on confiscation orders. It will be a brief overview on the process for when confiscation orders are made, in what circumstances, and how the court deals with payments or non-payments. It's quite a complex area of law, and so therefore, as I say, it will be just a brief overview. Confiscation was brought about to deprive offenders of the proceeds of their criminal conduct, so effectively money they've obtained from ill-gotten gains, which in turn obviously deters the commission of further offences, because obviously it's very tempting that even if somebody was to receive a prison sentence for an offence, if they know they have a pot of money waiting for them, it may seem all the more worthwhile. In cases of confiscation, not only do they serve the prison sentence for the substantive offence, they have to pay back what the courts say they owe as a result of their criminal conduct. And it obviously also reduces the profits available to fund further criminal enterprises. Confiscation was set out in the Proceeds of Crime Act of 2002, the vast majority of which came into force on the 23rd of March of 2003. So it sets out the legislative scheme for the recovery of criminal assets. Criminal confiscation is usually the most commonly used power, although there are other parts of the Act that deal with other ways of effectively taking money from an offender. Confiscation, though, can only be used after the offender has been convicted of an offence. It's all dealt with in Part 2 of the Act, but the other parts of the Act deal with proceeds of crime not requiring a conviction by the courts. So confiscation orders can only be made in the Crown Court. If an offender is convicted of a summary offence, so an offence which is obviously always only ever dealt with in the magistrates' court, then there is still the power for a confiscation order to be made, because the court may commit the offender to the Crown Court for confiscation proceedings. However, if the prosecutor in the case asks the magistrates to commit the offender to the Crown Court for confiscation to be considered, then the offender must be committed. So the Crown Court must proceed with considering confiscation if two conditions are met, and this is under Section 6 of the Proceeds of Crime Act of 2002. The first condition, set out in Section 6.2 of the Proceeds of Crime Act of 2002, is if the offender is convicted of an offence or offences before the Crown Court, or is committed to the Crown Court for sentence, or is committed to the Crown Court with a view to a confiscation order being made. Now obviously not all of those areas have to be fulfilled, just one of them, but it has to be one of those, and also the second condition has to be fulfilled, which is set out in Section 6.3 of the Proceeds of Crime Act of 2002. The prosecutor asks the court to proceed, or the court considers it appropriate to do so. So where confiscation is being considered by the court, the Crown Court must first determine whether the defendant has a criminal lifestyle, and that's set out in Section 64A of the Proceeds of Crime Act 2002. Now, the defendant does have a criminal lifestyle if the offence which is before the court fulfills one of the following three criteria. So, a defendant has a criminal lifestyle if the offence is specified in Schedule 2 of the Proceeds of Crime Act, and or the offence constitutes conduct forming part of a course of criminal activity, and or the offence was committed by the defendant over a period of at least 6 months and he has benefited from the conduct of that offence. Specified offences, as set out in Part 2, are generally all forms of trafficking, so people trafficking, drug trafficking is probably the most common, child trafficking, money laundering offences, blackmail, anything to do with pimps and brothels, intellectual property and counterfeiting, and any of those offences under the aiding and abetting, counselling, procuring or attempting any of the above offences. If the offence falls under any of those categories, then the offender is said to have a criminal lifestyle. There was also the offence is part of a course of criminal activity. So criminal activity is when the defendant has been convicted in the current proceedings of 4 or more offences on the same occasion, all committed after the 23rd of March of 2003, which is when this part of the Act came into force, and from which he or she has benefited from. Or alternatively, the defendant has been convicted of one offence after the 23rd of March of 2003 and he or she has benefited, and within 6 years of the start of these proceedings he or she has been convicted on 2 separate occasions of an offence committed before or after the 23rd of March of 2003, for which he or she has benefited. And that's obviously the second criteria for the criminal lifestyle. But remember, it doesn't have to be all 3 criteria. It can be 1, it can be 2, or it can be all 3.
এখন সময় সকাল 8:45
is found by the court must then determine whether the defendant has benefited from his general criminal conduct. General criminal conduct is conduct that at any time constitutes an offence in England or Wales, even if the offence wasn't committed in England or Wales. It can still be taken into consideration, and therefore the court can look at all of the defendants offending in any part of the world. They must determine whether the defendant benefited on the balance of probabilities. So it's a far lower test than the Crown obviously have to prove when proving an offence is committed beyond all reasonable doubt. So calculating the benefit that the defendant has obtained from his general criminal conduct, the court makes certain assumptions, namely any property that's held by, received by, spent or obtained after the relevant date was obtained as a result of the defendant's general criminal conduct, which is a very broad assumption to make. So basically anything that the defendant has owned, any assets at all after the relevant date, the court assume has come from the defendant's criminal conduct. The relevant date is the first day of a period 6 years prior to the start of the proceedings for the offence.